Welcome to the Judicial Committee of the Privy Council, where today we're hearing an appeal from the Court of Appeal of the Cayman Islands in the case of Primeo Fund and Bank of Bermuda, Cayman Limited. The appeal is concerned with some of the consequences of the Ponzi scheme run by Bernie Madoff. Primeo Fund are suing to try to recover losses, and an issue has arisen as to whether their claim is barred wholly or partly by a rule of company law, sometimes known as the reflective loss principle. I'm hearing this appeal with four colleagues whom I'll introduce now. First, Lord Hodge.
Good morning.
Lord Lloyd-Jones.
Morning.
Lord Kitchen.
Good morning.
And Lord Sales.
Good morning.
The appellant, Primeo Fund, are represented by a team of counsel headed by Tom Smith, Queen's Counsel. So I'll turn now to Mr. Smith and invite him to begin his submission.
Thank you very much, my lord. My lords, the proceedings in which this appeal arises are concerned with claims brought by Primeo Fund, acting by its official liquidators appointed by the Cayman Court against the former administrator and custodian to the fund. As your lordships will have seen, Primeo Fund carried on business as an investment fund, and its assets were almost entirely invested with Bernard Madoff Investment Securities Limited, which I'll refer to as BILMIS, and those assets were lost pursuant to the fraudulent Ponzi scheme carried on by Mr. Madoff and his associates. Following its entry into liquidation, Primeo brought proceedings in the Grand Court of the Cayman Islands against the respondents, the former administrator and custodian to the fund, seeking to recover damages in respect of the alleged breach of duties by the respondents. Now, my lords, there are essentially two forms of claim which have been asserted by Primeo. The first is what we've referred to as a strict liability claim, and that's a claim against the second respondent, the former custodian to the fund, on the basis that under the terms of the custodian agreement with the fund, it was responsible for the defaults of BILMIS as its appointed sub-custodian. And that's what's been referred to in the papers as, in effect, a strict liability claim. In addition to that, the second form of claim are breach of duty claims against both respondents, contending that they failed to discharge their contractual duties as administrator and custodian, respectively, owed to the fund under the administration and custodian agreements. And our case is that if they had performed their duties properly, Primeo would not have suffered loss. So those are, in essence, the two heads of claim. My lord, the courts below have upheld the strict liability claim as a matter of construction of the custodian agreement and as a matter of limitation. And there obviously is no argument that BILMIS did in fact commit various defaults and breaches whilst purporting to act as sub-custodian. However, both the Grand Court and the Court of Appeal held that the strict liability claim is barred by operation of the supposed reflective loss principle. So far as the breach of duty claims are concerned, the claims have been upheld as to duty and as to breach, and also in large part, although not entirely, as to causation and limitation. However, again, the courts below have held the claims to be entirely barred because of the operation of the reflective loss principle. Now, my lord, the argument as to the application of the reflective loss principle is based on the involvement of two other funds, two other investment funds, which also invested with BILMIS. They're called Herald and Alpha. The position in relation to those funds is that immediately prior to the 1st of May 2007, approximately 90% of Primeo's investments were held directly with BILMIS in what's called a managed account. And we refer to those as the direct investments. At the same time, about 10% were invested in Herald and Alpha, effectively through shareholders in Herald and Alpha in turn also invested with Bilmis. Now, at the beginning of May 2007, something called the Herald transfer took place. And under that transaction, Primeo, in essence, swapped its rights against Bilmis under its managed account for shares in Herald. And that was effected by way of an in-specie subscription for the shares in Herald. In essence, Primeo subscribed for shares in Herald, and the consideration for the subscription was the transfer of its rights against Bilmis under its managed account. Now, following that, Primeo had no direct investments with Bilmis, and its investments were shares principally in Herald, but also a small shareholding in Alpha. Now, the contention in support of the application of the reflective loss principle to bar Primeo's claims is that it said that the Herald transfer meant that Primeo was, from May 2007, only a shareholder in Herald and Alpha, and that this was Primeo's position at the time it issued the claim in the present proceedings, which took place in February 2013. It's also said that Herald and Alpha have their own claims against the second respondent, and that if those claims are successful, then they would make good Primeo's loss. Now, our position is that that is an incorrect analysis. So far as Primeo's direct investments with Bilmis is concerned, it's our position in our case that the relevant loss was suffered by Primeo prior to the occurrence of the Herald transfer. We accept, of course, that Primeo did subsequently receive shares pursuant to the Herald transfer, and that those shares have a value. And the value of those shares served to reduce Primeo's loss, which it had already suffered, and therefore reduce the amount for which it is entitled to claim damages. And that's, in our submission, a question when it comes to the assessment of damages. What we say is that the receipt of the shares under the Herald transfer didn't somehow convert the nature of the loss which Primeo had already suffered in relation to its direct investments, and which it had not suffered in the capacity of shareholder, into loss which is somehow reflective and which is not able to be claimed at all. Now, in our submission, the courts below fell into error, and that's because they followed the expansive approach to the reflective loss principle, which had been taken by Lord Millett in Johnson and Gore Wood. And in particular, they held that the application of the principle in the present case was justified by some of the policy justifications which had been identified by Lord Millett. In particular, the need, it said, to preserve company autonomy, to avoid prejudice to minority shareholders and creditors, and to avoid double recovery. And essentially, the approach of the courts below in our submission was to regard those policy justifications as being a sufficient basis for the application of the principle. Now, we submit that that approach was erroneous, as can now be clearly clean from the judgment of the Supreme Court in Marex. So far as the principle of company autonomy and ensuring that the company's creditors are not prejudiced is concerned, the Supreme Court pointed out in Marex that those are objectives or consequences of the rule in Foss and Harbottle. However, they don't, in our submission, require or justify the rule being applied beyond the circumstances which had been identified by the Court of Appeal in the Prudential decision. In other words, the need to preserve company autonomy and to protect creditors isn't itself a test for the application of the rule. It's rather the objective, ultimately, of the rule of Foss and Harbottle and the extension of that rule, as explained by the Court of Appeal in Prudential. Similarly, in our submission, the objective of avoiding double recovery is not by itself a sufficient basis for the application of the rule. The avoidance of double recovery does not require the claimant's claim to be barred in its entirety, as is currently the position in this case. As the Supreme Court explained in Marex, there are a number of ways in which the court can avoid double recovery, and principally simply as part of the assessment of damages. Now, my lords, we've always been clear that we're not seeking to make a double recovery, and we accept and have always accepted that we will give credit and need to give credit as part of the assessment of damages for the value of the shares which were acquired in Herald and Alpha, and for any distributions which have been received pursuant to those shares. And in our submission, ultimately, the question of double recovery is appropriately dealt with through that mechanism, and if necessary, the proceedings will be remitted back to the Crown Court to deal with the assessment of damages. Well, that's a summary, if you like, of the position where we've got to in terms of the decisions below, and also what our position is on this appeal. For the purposes of these submissions, subject to your lordships, I was proposing to deal with matters in the following order. Firstly, I was going to focus on Primeo's direct investments. In other words, the 90% held directly with Bill Miss prior to the Herald transfer, and briefly explain the nature of those claims and how it is that we say they arise. Secondly, I was intending to make some submissions on the type of loss to which the prudential rule applies. Essentially, that's a question of the decision, and looking at the decision of the Supreme Court in Marex. Thirdly, I was going to deal with what's been referred to as the timing point, and that's the question: at what point do the requirements for the application of the prudential rule have to be assessed? And in particular, does one look at that at the date the proceedings are commenced, or does one look at it, as we say, at the date when the loss is suffered? Fourthly, I was going to turn to the requirement for the company and the claimant to have a claim against the same wrongdoer. Fifthly, the question of the merits test, and that's the question of what threshold merits test the company's claim has to satisfy in order for the prudential rule to be applicable. And then finally, I was going to deal with the indirect investments, including the 10%, which at the date immediately before the Herald transfer was held by Primeo through Herald and Alpha, and to which we accept that different considerations apply. So, subject to your lordship, that was the course I was proposing to take.
Can I just mention that the question that you've touched on already of when was loss actually suffered, so as to complete the cause of action, is one which we'd certainly like you to take some time on. Yes.
Well, I was going to deal with that really first of all, if I may, because it goes to the question of the nature of Primeo's claims. And I was proposing to do that essentially by reference to the Court of Appeal judgment and the analysis which the Court of Appeal adopted in relation to those claims. I should say at the outset that your lordships will appreciate that there is a second hearing in this matter, which is scheduled for later on in the year. And the respondents in particular take issue with certain aspects of the Court of Appeal's analysis of loss. And that's an issue which will, I think, come before this court in the autumn. But for present purposes, I'm proceeding on the basis that the Court of Appeal's analysis on that is correct. That's the base on which we're proceeding for the purposes of this hearing, and the question of whether or not our claim is barred by the reflective loss principle. So, my lord, against that background, I was going to turn to the nature of Primeo's claims, which are the subject of the present appeal. And I'm going to start, if I may, with the strict liability claim, which is the claim which arises under the terms of the custodian agreement, which was in place between Primeo and the second respondent. My lords, the custodian agreement permitted the custodian to appoint a sub-custodian to perform its functions, but on terms that the custodian remained liable for any negligence or willful breach of duty on the part of the sub-custodian. Now, the way in which the strict liability claim then arises was explained by the Court of Appeal, and perhaps I could ask your lordships to turn up the judgment of the Court of Appeal. I think we can go straight away to paragraph 186, which is page 238 of the electronic bundle. And perhaps I can just orientate your lordships. Perhaps if we can just go firstly to page 237 of the bundle, you'll see there's a section beginning just prior to Roman numeral, so beginning just prior to paragraph 183, headed Roman numeral 10, the strict liability claim. So this is the part of the judgment where the Court of Appeal begins to analyse the strict liability claim. And if we go to page 238, paragraph 186, your lordships can see that in the first sentence of paragraph 186, the Court of Appeal summarised what our case was in relation to this part of the claim. And we said that, and this is our argument on appeal against the findings of the judge, that the judge should have found that Primeo suffered actual loss every time that cash transferred by the second respondent to Bilmis qua sub-custodian was misappropriated by Bilmis for use in the Ponzi scheme, thereby giving rise to a right to damages measured by the amount of cash so transferred, less any recoveries made. And that was the case that was put. And then there was some argument about the state of the pleadings. But if you go then to 19...
Mr. Smith, sorry, could I just ask, I was looking at paragraph 184.
Yes.
What did the full statements of account issued by Bilmis actually say? So I understand that money is transferred into Bilmis.
Yes.
And it's giving an account of what it's done with that money. What would that account actually say?
Well, generally what the statements of account showed Bilmis to hold amounts of US treasuries at the month end. So what Mr. Madoff explained as his investment strategy was to move at the month end into holdings of US treasuries, and therefore he produced account statements for the month end showing holdings of US treasuries, basically.
So it would be actual financial instruments, in the name of Bilmis, sorry, held by Bilmis as legal owner.
That's correct, yes.
Yes, all right, thank you. And
these were presumably works of fiction.
Correct. Yes, that's right. But that's certainly correct in terms of the actual material which he produced, or he and his associates produced. So 186, essentially our case as put was to say, well, every time money is advanced into Bilmis, then loss is suffered, in the sense it goes into his Ponzi scheme and is lost. There was then, I think we can skip over an argument about the state of the pleadings, but if your lordships go to 193, page 241 of the electronic bundle. You'll see here the case, our case in terms of duty was put by reference to the obligation on the custodian under the custodian agreement to keep the cash safe. And that's 193. And then perhaps most relevantly, 195, the Court of Appeal accepted the proposition that the second respondent, and therefore Bilmis, as sub-custodian, owed a duty of safekeeping in respect of cash, and that duty was owed pursuant to clause 6A of the 1996 custodian agreement. And they further find that that was the basis of the judge's finding that Bilmis had willfully breached its duties as sub-custodian by misappropriating or misusing Primeo's money. So essentially, under the custodian agreement, the second respondent owed a duty to keep the cash safe. It appointed Bilmis as its sub-custodian to perform that duty, and Bilmis breached that duty willfully by effectively using the money for the purposes of a fraudulent Ponzi scheme. And then you'll see they make the same point at 196 on page 242 in the second sentence. As we've held, the second respondent, and therefore Bilmis, also had a duty to keep cash safe under clause 6A of the 1996 custodian agreement, and it was this duty that was breached when Bilmis misapplied the cash sent through or sent via the second respondent for investment.
And Mr. Smith, just so as I'm clear in my mind, the using it in the Ponzi scheme is essentially drawing on that cash as and when needed to pay out investors who are seeking to redeem instruments.
That's right, yes.
Yes, all right, thank you.
That's exactly right. So that's the nature of the legal duty, if you like, and the nature of the breach of the custodian's duties.
Can I follow that up, Mr. Smith? So one sometimes sees schemes where what's going on is that the investor is buying redeemable shares, and he can choose when he wants to redeem them, and he then gets an amount. He then gets a payment out of the fund based on the NAV. But that's not, as I understand it, what's going on here. You are buying. You're actually buying supposedly securities.
That's right.
Is that right? Which are simply being held on your behalf.
That's right. So just to be clear, the investors in Primeo itself invested on the basis which your lordship has just described, because that's how Primeo was structured. So anyone putting money into Primeo, if you like, the ultimate investors did invest on that basis. But then in terms of Primeo making its own investments, it simply effectively advanced the money to Bilmis and was told that Bilmis was managing those investments. It was shown that Bilmis was holding treasury bills at the month end, but in fact, we know that it wasn't doing that, and those statements of account were fraudulent.
Thank you.
So, my lord, as I say, that's the nature of the relevant duties and breaches. There was then a debate which took place before the Court of Appeal, beginning at page 197 of the judgment, as to the time at which loss was suffered. And that follows through from paragraph 197 onwards. There was discussion in particular of the NI credit case, and also when you get to paragraph 210 on page 248, another decision of the Court of Appeal, the English Court of Appeal, in a case called DNB Mortgages against Bullock and Lees. And the Court of Appeal's conclusion, when you get to paragraph 215 on page 251, they say, first of all, the loss claimed for in respect to Bilmis's misappropriation of the cash, namely the cash misappropriated less all recoveries received by Primeo, is loss in respect of which Bilmis's duty to keep cash safe was owed. And then 216, further putting on one side for the moment the effect of the Herald transfer, we find that Primeo did indeed suffer actual loss each and every time money sent by Primeo by the second respondent to bill for investment was misappropriated for the reasons advanced by Mr. Smith. And then if you go on to they then effectively justify that by reference to NICredit and also Law Society against Sefton. And 217, they explain in summary the analysis, which is by reason of the investments that were made, the value of the right actually received by Primeo was manifestly less than the value of the bargained for right. Instead of having a right to delivery of securities, Primeo received shows in action popped up by fraudulent Ponzi scheme. It follows that upon misappropriation of the money, Primeo suffered an immediate actual loss measured by the value of the money misappropriated, with credit being given for all recoveries received. So their analysis is that the loss was suffered essentially when the cash was invested and then misappropriated. Now, as I say, the respondents, I believe, take issue with that analysis, and that's a matter which is on the agenda for the appeal in the autumn. But so far as this appeal is concerned, I'm proceeding on the basis that that analysis is correct, and the question is whether, assuming that analysis is correct, the Court of Appeal was correct or wrong to determine that the claim was barred by the reflective loss principle. Because the effect of the decision of the Court of Appeal is that, notwithstanding that analysis of loss, they held that the claim was nevertheless barred by the reflective loss principle, and we say that was incorrect. So, my lord, just to complete the analysis of the strict liability claim, if your lordships go to page 252, at paragraphs 219 to 221, the final part of the analysis was that they concluded that the Herald transfer didn't have the effect of nullifying the loss. And that's dealt with at 219 to 221.
Mr. Smith, you tell us you're going to be addressing us on the assumption that the Court of Appeal's analysis was correct.
Yes.
Is that common ground for the purposes of this hearing, that we determine the issue of reflective loss on the assumption that the Court of Appeal's analysis of when loss was suffered is correct?
Well, I mean, my learned friend will perhaps answer for himself, but I mean, in my submission, it has to be. I mean, there's nothing in the respondent's written case for this appeal which takes issue with the Court of Appeal's analysis of loss. So, I mean, there's no engagement, for example, with the NICredit analysis or Law Society and Sefton or any of those cases. So, I mean, on that, that's the base on which we're proceeding, and certainly the Court of Appeal's analysis stands unless and until it was to be set aside.
Yeah. Yes. So the argument, I presume, is that is as to whether subsequent to that, when your clients became shareholders in Herald and Alpha, make a critical difference.
That's exactly right. So as we understand it, that's essentially the landscape of this appeal.
Right.
And I think that's essentially what we've called the timing point. So that is, I think perhaps the nub of it, although I need to lay a little bit of the groundwork before we get to that.
And I'm so sorry, Mr. Smith, just to keep things clear in my own mind, my lord said it's subsequent events involving Herald and Alpha. As I understand it, on the direct investments claim, it's just Herald that comes in the frame later on. Is that right?
That's exactly right. Yes. So it's just Herald that comes in the frame later on.
Thank you.
You're
I just wanted
absolutely
to-
right.
Not to lose my path during this. Thank you.
No, not at all.
I'm sorry, just while we're on this point, but am I right in understanding that the question whether the Court of Appeal's analysis and conclusion at 216, 217 is right will be an issue in the hearing in the autumn?
I believe so. Yes, I believe my learned friend is seeking to challenge that by way of a cross appeal, which he's put in. I think he seeks to so argue that in the hearing in the autumn.
So what happens if we just say, for the sake of argument, we decide the reflective loss issue on the assumption you're inviting us to make, and then we decide in the autumn that that assumption was incorrect?
Well, it may be the case that the final disposal of this appeal on that scenario wouldn't be able to take place until the autumn. But the reflective loss principle and the reason for this hearing, as I understand it, is effectively it's said that the reflective loss principle is a complete answer to our claim, because even if the Court of Appeal is right on their loss analysis, we don't go anywhere because we run into the roadblock of reflective loss. And we say that's wrong, and that reflective loss isn't a complete roadblock. And essentially, this appeal is concerned with that question, if I can put it in that way.
I see. So effectively, there may be a knockout blow against you at this stage, but if there's not, then the issue of reflective loss may still have to be looked at again in the autumn.
I think that must be right, and to the extent my learned friend is taking issue with the loss analysis of the Court of Appeal, I think that is an issue that would have to be looked at again in the autumn if he's pursuing that point.
Thank you very much.
So, my lord, that just deals with the strict liability claim. Just to make 2 points about that. The relevant period for the claim is the 7th of August 2002 to the start of May 2007, because that's the period during which the second respondent was custodian and Bilmis was its sub-custodian, and during which Primeo had direct investments with Bilmis. And the claim only relates to what we've called the direct investments. And the short point, which we'll come to, is that the claim itself is not in our submission related to or derived from any shareholding held by Primeo in Herald or Alpha. It's not a claim for loss suffered by Primeo in its capacity as a shareholder in those companies, or indeed in any companies. And the form of the loss is not a diminution in the value of any shares or in the distributions from any shares. So that's the strict liability claim. Now, the other type of claim which I mentioned are the breach of duty claims, which lie against both respondents as former administrator and custodian.
I'm so sorry. It's just for the purposes, again, of clarity for me. I think you said that for the fictional treasuries, Bilmis purported to be the legal owner of those. So was the nature of the custodian relationship that they were held on trust for Primeo?
It's not necessarily a trust analysis in the sense that it may not depend on Bilmis actually having identifiable segregated assets in its control that could be subject to a trust. The way the custodian relationship, so in this case, has been analysed is effectively as contractual obligations to deliver up securities. So the custodian, so the customer has a contractual claim against its custodian for the delivery up of securities as recorded as showing on its statement of account.
Yes, right, thank you.
So, my lord, the other type of claim then is the breach of duty claims, which, as I say, lie against both respondents as the former administrator and custodian respectively. I'll start with the administrator claim, as we've called it. The allegation of breach, which was upheld by the courts below, was that the first respondent was negligent in its determination of the net asset value of the shares in Primeo, and that as from 2005, it was indeed grossly negligent in that default. And you can see that in the Court of Appeal's judgment at paragraph 266, page 265. So it's paragraph 266, I do apologise, page 265 of the electronic bundle. And they begin by identifying the relevant duty. The administration agreement required the first respondent to calculate on each valuation day the net asset value upon which Primeo and its shareholders could properly rely for the purposes of transacting subscriptions and redemptions. It was an implied term that the reasonable care and skill was to be exercised. And then you'll see 267, our contention was that the first respondent was at all material times grossly negligent in calculating the net asset value on each valuation day. The judge held that although the first respondent was negligent from October 2002 onwards, it was not guilty of gross negligence until the 2nd of May 2005, being the first valuation day after the point when the second respondent first issued custody confirmations. And we'll come to that in a moment, but the appeal from that finding was dismissed by the Court of Appeal. So essentially that was the question of duty and the question of breach. What's also relevant for this claim is obviously the question of causation, because this is a breach of duty claim. Therefore, in order to establish an entitlement to damages, it wasn't incumbent on us to establish causation. Now, that obviously involved consideration of what would have happened in the hypothetical counterfactual where there had been no breach of duty. And in broad terms, the case on causation, which was upheld by the Court of Appeal, is based on the provision by the respondents of what are called custody confirmations to Primeo's auditors in April 2005, and then again in February 2006 and February 2007. And these were confirmations produced by the respondents, which enabled Primeo's auditors then to give an unqualified audit opinion on its accounts. And to put the matter shortly, essentially Primeo's auditors were concerned to make sure that they had audit evidence that Primeo's investments with Bilmis actually existed. So they were concerned to make sure that before they provided an audit opinion on Primeo's accounts, they had some audit evidence to corroborate the existence of those assets. And the way in which they obtained that evidence was effectively getting what's referred to as a custody confirmation from the second respondent, specifically that those assets were held in its custody. And that it was therefore on that basis that the auditors who were Ernst & Young were then able to provide an audit opinion and to sign off on the accounts. Now, our case on causation was broadly that without those custody confirmations, no audit opinion would have been given on the accounts, and that without such an opinion, Primeo would have had to have withdrawn its existing investments from Bilmis and wouldn't have replaced any further funds with Bilmis for investment. Now, obviously that analysis raises questions amongst others as to what the auditor would have done in that hypothetical counterfactual. In other words, what would have happened if the auditor hadn't been able to obtain a custody confirmation from the respondents. And in relation to that, the Court of Appeal held that we had established causation on a loss of a chance basis, because there was a real or substantial chance that without the custody confirmations, the auditors wouldn't have issued clean audit opinions. And you can see that in the Court of Appeal's judgment at paragraph 331, which is page 295 of the electronic bundle. And that matter was left, as you can see from paragraph 343 on page 300, that matter was left on the basis that the question of the loss of the chance will have to be determined by the Grand Court. So the percentage loss as it is hasn't yet been determined by the Grand Court. And assuming that this claim isn't barred by the reflective loss principle, it will fall to be remitted back to the Grand Court to determine the percentage loss of a chance. And you can see that in paragraph 343 on page 300, it's the final sentence. Now, I'm obviously, your lordships aren't being asked on this hearing to rule on the rights or wrongs of that analysis. The reason for taking your lordships through that analysis is so that your lordships can understand the nature of the claims, because that's obviously relevant when it comes to the question of assessing whether and to what extent the reflective loss principle applies. Now, so far as the custodian claim is concerned, the causation analysis is the same, but the underlying contractual obligations and breaches are, however, founded on the custodian agreement and not on the administration agreement. And you can see from the Court of Appeal's judgment at paragraph 242, on page 259 of the electronic bundle, the relevant provisions of the custodian agreement, which are set out in paragraphs 242 and 243, they're clauses 16b and 16e, and then in 244, they refer to the two specific obligations which were imposed on the custodian in connection with the appointment of a sub-custodian. The first is what was called the ongoing suitability duty, and the second is what was called as the most effective safeguards duty. So those are specific contractual duties imposed by the custodian agreement on the custodian. And the two together were referred to as the ongoing supervisory duties. And then in 245, our case was that those duties were breached. And the judge's conclusions on those points were upheld by the Court of Appeal. So effectively, it was the concurrent findings as to duty and breach between the Grand Court and the Court of Appeal. Now, again, the short point in relation to those breach of duty claims, insofar as they relate to the direct investments, is they're not related to or derived from any shareholding held by Primeo in Herald or Alpha. They are not claims for loss suffered by Primeo in its capacity as a shareholder in those companies, or indeed, again, in any companies. And the form of the loss is not a diminution in value of any shares or in distributions from shares. Essentially, what Primeo is saying is that if the custody confirmations hadn't been provided, then Primeo would have withdrawn its direct investments held by Bilmis, wouldn't have directly invested any further assets with Bilmis, and its loss has been suffered in that form. So that's the nature of the two heads of claims which are being advanced. Now, against that context, I was going to turn to the next topic.
I'm sorry, Mr. Smith,
again,
just to understand, when you say the nature of what would have happened if there hadn't been a breach of duty is that there'd have been a withdrawal by Primeo of its Bilmis investments, and that it would have invested no more. I mean, first of all, what was the case in relation to withdrawal of the investments? Because that would be Primeo drawing on presumably the Ponzi scheme itself. Is that right?
Yes, that's right. So, I mean, our case on that, our case on that is that Primeo would have been paid out by Mr. Madoff, because at that time the Ponzi scheme was effectively ongoing. So essentially, we submit as part of our case that if the custody confirmation hadn't been given, then Primeo would have sought to withdraw its investments, and that Mr. Madoff would have redeemed the investment.
So in effect, that's a sort of timing point. At that stage, Madoff had enough money swashing around to be able to make it work. And as I understand it, you say we're now talking what, 2005, 2006, 2007. At that time, if you'd withdrawn, you'd have been one of the lucky investors to get the money back.
That's right.
And what about investing no more? Do we have any figures as to how much was invested, which you say would have been drawn back out, and to what extent the new investments were being made?
The answer to that is we do have figures on that, because there were reports from quantum experts. I don't have them at my fingertips, but we can certainly provide your lordship with figures. I mean, it depends obviously on exactly which moment in time you're looking at, and there are causation theories that run at 2005, 2006, and at 2007. But the information is available to work out both the withdrawal claim and the no further investment claim at each of those dates.
But can we take it that there were in fact new investments going in?
Yes, you can take it that's correct. Yes.
All right. Thank you very much.
So against that background, I was then going to turn, before we come to the timing point, just to the question of whether the rule in Prudential applies to bar these claims. And in our submission, it does not. The scope and rationale of the rule in Prudential have now obviously been clearly and authoritatively explained by the Supreme Court in Marex. If I could just trouble your lordships to turn up Marex, obviously your lordships will all be very familiar with it. I was just going to go, if I may, straight to paragraph 79 of the judgment of Lord Reed, which is at page 1030 of the electronic bundle. Because I think it's perhaps paragraph 79 which most conveniently summarises the essence of the decision in Marex. And on the basis of the Supreme Court's analysis, the principle or rule applies to claims which are brought by a shareholder in respect of loss. So it's focusing on the loss and the nature of the loss, which he has suffered in that capacity, in other words, in the capacity of shareholder, and which is in the form of a diminution in share value or in distributions. And it has to be in consequence of loss sustained by the company, and the company must itself have a cause of action against the same wrongdoer. But what's important in our submission is that the focus is very firmly on the question of loss, and in particular on the nature of the loss. And we'll come to that in a moment. But you get, I think, the same from paragraph 89 on page 1032. And in particular, the third sentence, again, of Lord Reed. The rule in Prudential is limited to claims by shareholders that as a result of actionable loss suffered by their company, the value of their shares or of the distributions they receive as shareholders has been diminished. And then also, I think to the same effect, Lord Hodge at page 1035. This exclusion, as Lord Reid has stated, relates only to the diminution in value of shares or in distribution which the shareholder suffers in his capacity as a shareholder as a result of the company having itself suffered actionable damage. Now, in a sense, one could perhaps stop there and ask whether the claims which I've described and as explained by the Court of Appeal fall within the requirements set out in those paragraphs. And in our submission, they don't, because they are not, in respect of losses suffered by Primeo in the capacity of shareholder, and the losses claimed don't take the form of diminution in value of shares or in respect of diminution in value of distributions from shares. But it's also helpful in our submission to understand the rationale for the rule as explained by the Supreme Court. In our submission, that rationale is founded on what the Supreme Court described as the unique relationship between a shareholder and the company in which the shareholder has invested by acquiring shares. Effectively, the rule is born out of the unique nature of that particular relationship between a shareholder and the company. And as your lordships know, that's because although a shareholder invests in a company and thereby acquires shares, the assets of the company obviously belong to the company and not to the shareholders. And moreover, it's part of the bargain by which the shareholder invests in the company that he agrees that the assets of the company are subject to the control of the organs of the company as established by its constitutional documents. That's in essence what the shareholder is agreeing to when he makes his investment, when he provides his subscription to the company, and in return for which he receives shares. He's agreeing that his investment will be subject to the board of directors of the company in general meeting, and the various requirements of the Articles of Association and any other company documents. The shares themselves are a right of participation in the company on the terms of those documents. And in our submission, it was very aptly put, if we may say so, by the Court of Appeal in Prudential, and I think this is picked up by the Supreme Court in Marex, by the phrase that by investing in the company, the shareholder accepts the fact that the value of his investment follows the fortunes of the company. Now, as your lordships know, what that means as a matter of company law is that a shareholder can't generally bring a claim which belongs to the company. That obviously is the rule in Foss and Harbottle itself. But also the extension of that rule in Prudential is that the shareholder can't bring his own claim which mirrors the company's claim for diminution of value in his shareholding. And in our submission, as explained by the Supreme Court in Marex, that is because permitting a claim for that type of loss would contradict the principle that by acquiring a shareholding, the shareholder has agreed that his fortunes follow those of the company, that the company is under the control of its organs, and that it's for the company under the control of those organs to seek to recover loss caused to the company by the wrongdoer, even if his actions also caused loss to the shareholder. And the fundamental point of our submission, is all of this is born out of the fact that it was the decision of the shareholder to invest in the company and his agreement that his investment would be subject to and regulated by the constitution of the company. And the rule in Foss and Harbottle and the extension of the rule in Prudential is all concerned with not allowing that fundamental bargain to be subverted. What the shareholder can't do, having placed his investment under the control of the company, is then in effect subvert the constitution of the company by taking direct action. But it's all inherently tied up with the fact that the shareholder has in the first place made his investment in the company on those terms. That's what he's signed up to. And in our submission, that is the essence of what the Supreme Court decided in Marex, and that manifests itself in the way that the rule in Prudential is expressed in those paragraphs which I've just identified. Now, pausing there, the present situation in our submission is far removed from the type of situation where that rationale for the rule may apply. So far as the direct investments are concerned, this is not a case where the relevant claims arise out of investments which Primeo in fact made in Herald and Alpha. It's not a case where Primeo subsequently suffered diminutions in the value of those shares and is now seeking to recover that loss. Rather, the claims relate to investments which Primeo made directly with Bilmis. And it was no part of those investments that there was any bargain made by Primeo in its capacity as shareholder of Herald and Alpha, or indeed a shareholder in any company. In relation to the direct investments, Primeo didn't agree that those investments would be under the control of any company. They remained at all times its direct investments, which it held against Bilmis. So in our submission, the rationale for the rule simply doesn't apply in relation to those investments at all. It really is far removed. And if we revert back to paragraph 79 of Marex, and leave aside for the moment the need for the company to have a claim against the same wrongdoer, there are two requirements for the rule to apply. The first is that the claim must be for loss suffered by the claimant in its capacity as shareholder in the company. And the second is the loss suffered must be in the form of diminution in the value of its shares or in distributions made from the shares as a consequence of loss being sustained by the company. So there's essentially a requirement that the loss be suffered in the capacity as shareholder, and also that the loss must be in the particular form of a diminution in value of shares or distributions. And in our submission, neither requirement is satisfied in the present case in relation to the direct investments. For the direct investments, the loss which Primeo is claiming for is not loss suffered by it in its capacity as a shareholder in Herald or Alpha, and the loss is not in the form of a diminution in value of shares in Herald or in Alpha or in distributions from those shares. So pausing there, in our submission, in our respectful submission, it's clear that the reflective loss principle, or the prudential rule, however one wishes to describe it, as explained by the Supreme Court in Marex, doesn't apply to the claims in respect to the direct investments. And that's both as a matter of simply looking at the way in which the requirements for the rule are now expressed in the judgments in Marex, but also digging deeper and looking at the actual rationale for the rule as explained by the Supreme Court in Marex. So, my lords, that then brings me to the timing point, because this now appears to be the crux of the respondents' argument on the present appeal. In particular, they say that the application of the prudential rule is to be assessed by reference to the facts and circumstances existing when the claim is brought, by which they mean when the proceedings were issued. And that's paragraph 83 of their written case. In the present case, the date when the claim was brought was February 2013, because that's when the writ was issued. And they then say that because the Herald transfer took place on the 1st of May 2007, and that had taken place by the time the proceedings were issued, Primeo's investments were at the time the writ was issued held solely by way of shareholdings in Herald and Alpha, and therefore the claim, when issued, was barred by the rule in Prudential. So that is the essence, I believe, of the argument that's been put on the timing point. We say that is wrong, and that what matters is the position at the time the loss was suffered, not at the time the proceedings were issued. Now, the main point we would make in support of that submission is by reference to the nature of the Prudential rule as explained by the Supreme Court in Marex and by the Court of Appeal in Prudential itself. And in our submission, the focus of the rule in Prudential is on the question of the nature of the loss. It focuses on the question of the capacity in which the claimant has suffered the loss and on the form of that loss. And therefore, what matters is the state of affairs as at the time the loss was suffered, because it's ultimately a question of characterising the nature of the loss. And as the Supreme Court explained in Marex, the effect of the rule is to bar the recovery of a particular type of loss. That's what the rule does as a matter of legal analysis, and specifically it bars the recovery of loss suffered in the capacity of shareholder and in the form of a diminution in the value of shares and distributions. And the law achieves that by in effect deeming such loss to be irrecoverable by the shareholder, or putting it another way, where a shareholder suffers that specific type of loss and where the company also has its own cause of action against the same wrongdoer, then the law does not recognise the shareholder as having suffered a loss distinct from the company's own loss. So it's a question of looking at the loss and ultimately asking oneself, well, is the nature of that loss such that the law doesn't regard it as distinct from the company's own loss? Or putting it another way, is it a particular type of loss that the law simply deems it to be irrecoverable? But the focus entirely is on the question of the nature of the loss, and the effect of the rule is to bar the recovery of such loss as falls within the scope of the rule. Now, against that context, in our submission, the correct analysis in this case is that the loss which Primeo suffered in relation to the direct investments was not suffered in its capacity as a shareholder or in the form of diminution in value of shares or distributions as a consequence of an actionable wrong to the company. When it was suffered, it was not loss, not a form of loss which the law regards as being indistinct from the company's own loss, or a form of loss which the law deems to be irrecoverable by the shareholder. When it was suffered, it was a form of loss which the law regards as distinct and which the law regards as recoverable. What then happened is that after such loss had already been suffered, Primeo then acquired shares in Herald as a result of the Herald transfer transaction in May 2007. In our submission, the acquisition of such shares did not alter the nature of the loss which had already been suffered. It didn't transform that loss from being distinct loss into indistinct loss. It didn't transform that loss from being recoverable loss into irrecoverable loss. The acquisition of the shares obviously is relevant for the assessment of damages, and as I've said, we've always accepted that credit will need to be given for the value of the shares and the distributions received from them. But that is merely a consequence of the ordinary rules for the assessment of damages requiring the claimant to bring into account any benefits which it has received which have served to reduce its actual loss. It's simply one of the principles that go to the compensatory nature of damages. It's nothing to do with the nature of the loss being changed so that its status moves from being recoverable loss to irrecoverable loss. Now, in our submission, it's very difficult as a matter of law to see any basis for saying that a subsequent acquisition of shares can change the nature and character of loss which has already been suffered. It may mitigate the amount of the loss which has been actually suffered, but as I say, that's a different matter. I'm sorry, Lord Kitchen.
Could I ask this? As I understand it, you accept that at any time up to December 2008, the investments could have been withdrawn at their full face value, their full notional value.
Yes, that's. I mean, that's where we certainly haven't. There isn't a causation case that is being advanced post May 2007. So the causation arguments that have been run by us and which have been upheld by the Court of Appeal are effectively at February 2005. Sorry, April 2005, February 2006, February 2007. So those are the relevant dates. We haven't advanced, not advancing a case on causation post May 2007.
So I think what I'm struggling to put my finger on is that once the Herald transfer had taken place, what was the nature and extent of your loss up until the collapse?
Well, in our submission, in relation to the direct investments, we had already suffered loss when the cash was advanced to Bilmis and was misappropriated. And that's, in effect, the analysis that was upheld by the Court of Appeal.
But despite, sorry to interrupt you, but despite that finding of the Court of Appeal in relation to the position prior to the transfer, after the transfer, you accept that up to the date of the collapse, you could have recovered your full investment by selling the shares that you held in Herald.
Well, as I say, we don't accept that up to the date of the collapse, because the last date for our causation analysis is prior to the Herald transfer in February 2007. But in any event, the correct analysis in our submission is that loss was suffered when the cash was put in, and effectively Primeo received in return for the advance of that cash a right against a Ponzi scheme. Now, in circumstances where Primeo did not in fact withdraw its investments, one simply has to give credit for the right which Primeo did receive as against the loss which is actually suffered. Primeo did not in fact withdraw its investments here, and what in fact happened is it deposited substantial amounts of cash with Bilmis, and in effect, in return for that, it received rights. Now, as a matter of substance, the right it received was a right against a Ponzi scheme. Now that isn't a right without value, because the way in which the Bilmis estate has been managed by the trustee means that there are realizations, and we accept that we have to give credit for the actual value of that right. But it doesn't mean in our submission that Primeo hasn't suffered any loss in circumstances where it did not in fact withdraw its investments. I mean, if Primeo had in fact withdrawn its investments successfully, clearly we wouldn't be here. We wouldn't be here. But I mean, obviously that isn't the case. So the question of the value question is, what's the value of that shows in action, and that has to be then offset against the loss which Primeo suffered through the misappropriation of its cash. So that's Just to go back to where I was, I mean, I think the first point we would make in relation to this is that the focus is on the nature of the loss, and that if the loss is of a nature that doesn't engage the rule because it is distinct loss and it's recoverable loss, then a subsequent acquisition of shares doesn't change that nature. Rather, the correct analysis is that may mitigate the loss, and that's something that falls to be taken into account as part and parcel of the process of assessment of damages. Now, there's just one further point perhaps to add to that, which may be ultimately a forensic point, but it perhaps serves to highlight the force in the point I've just made. The prudential rule obviously only applies where the company has a claim against the relevant wrongdoer. And in the present case, the respondents can only argue that the rule applies because Herald's custodian and administrator was the second respondent. But that was mere happenstance. Herald's administrator or custodian could have been another entity entirely. It could have been Citibank, it could have been State Street, it could have been any other financial institution that carries on custodian business. And if that had been the case, then there wouldn't be any basis for arguing that the rule applies at all. So if, for the sake of argument, Primeo had acquired shares in Herald and Herald's custodian had been State Street, say, then there wouldn't be any basis, any conceivable basis for saying that the reflective loss rule could apply, because one wouldn't have a situation where the company, as it were, in this case Herald, had a claim against the same wrongdoer. Now, that highlights that the respondent's proposition has to be to say that it's only a subsequent acquisition of shares with certain characteristics which have the effect of transforming the nature of loss suffered, which is recoverable, into loss which is irrecoverable by operation of the prudential rule. Specifically, they have to say it's an acquisition of shares, subsequent acquisition of shares in a company which happens to have its own cause of action against the same wrongdoer. So effectively, what they have to say is, well, you may suffer a recoverable loss in the first place, but then if you happen to acquire shares in a company that happens to have a claim against the same wrongdoer, then that somehow transforms the legal nature of the loss from recoverable and distinct loss into irrecoverable and indistinct loss. Now, in our submission, there isn't any legal basis for that approach. It's very difficult simply to see what the legal foundation is for saying that there is a transformation of loss of that nature and in those specific circumstances. So, Lord Kitchen.
Could I just ask this in that connection? You accept that if Herald and Alpha's claims were to succeed, including in relation to the sums that were originally made as direct investments, then Primeo's loss would be made good via an increase in the value of Primeo's shares in those companies.
Yes, I think that must be, if the claims were to succeed in the full amount of the amounts that have been pleaded, I think that must be right.
Well, can I ask you, could Herald have a good claim in respect of the supposed value of the supposed investments?
I'm sorry, I didn't quite follow the. I'm not sure I quite heard you fully, Lord Reid.
What's going through my mind is that before the 1st of May 2007, what's going on is a fraud, and investors are giving their money to Madoff and the money is being stolen. And what they are getting instead of the investments that they understood they were receiving, all they have is a cause of action. Well, they have they have a right as against Madoff, which or via Plymouth, which may or may not be of real value depending on when they exercise it.
Yes.
Of course, they don't know about its existence. They don't know about it.
Yes, quite.
Anyway, come May 2007, Herald supposedly acquires all these fictitious securities. It doesn't actually acquire anything other than its own rights, I suppose, against Madoff.
That's right. So it effectively acquired the shows in action against Bilmis under the managed account.
Yeah, I'm wondering if Herald were to sue its custodian or its advisors, if you like, for their negligence, what could it ever? How much could it ever recover? I mean, could it recover the amounts that people like Primeo had actually put in the form of cash years earlier, and which had been stolen years earlier?
Well, I mean, not necessarily. I mean, but this sort of highlights one of the other difficulties which we're going to come to in a little while, which is that one of the issues the present case throws up is that Herald's claim is governed by Luxembourg law, not Cayman law, and subject to Luxembourg jurisdiction, and therefore one can't assume necessarily that the principles we're familiar with translate across. But one can see there are all sorts of issues potentially with Herald's claim. And I think that comes to the question of one of our other points, which is, how good does Herald's claim have to be for us to be shut out?
Well, I mean, Lord Kitchen's questions, I think, are based on the premise that Primeo's losses could be recovered in substance through proceedings at the instance of Herald. And I'm just wondering whether that's actually right, or whether at the stage when Herald took over the supposed portfolio of investment, things were at such a pass that the money that had already been stolen would be beyond recovery by Herald.
Yes. So, Lord Hodge.
Could I follow that one up? My understanding is Herald tried to get out of the share transaction on the basis that that Primeo had not given that which Herald was expecting to receive in the assignment. So
Yeah.
the assets under management weren't the assets under management, and Herald's defence failed.
That's right.
So they were treated as if that Primeo had given full value for the shares.
That's right. So essentially, there was an argument based ultimately on the doctrine of mistake, really, which it was said there was a common mistake as to the value of the Madoff managed account. And that was dismissed by the judge at first instance in Cayman and not then appealed. And essentially the argument, essentially was dismissed on the basis that Primeo didn't give any warranty as to the value of the shows in action in respect to the managed account. Therefore, Herald received what it had bargained for, which was the rights in respect of the managed account. And as part of that transaction, no warranties were given that the rights had a particular value. And therefore, the transaction wasn't void for mistake, because both sides of the bargain, as it were, had been performed. Primeo had received the shares, and Herald had received the rights against Bilmis relating to the managed account.
Yes, on the basis that the NAV was correctly stated, without no warranty, but Herald was buying on the understanding that it was receiving a correct NAV.
Well, that's the Herald was acquiring the managed account assets on the basis of the statements that have been produced by Mr. Madoff. That's right. But of course, Primeo was acquiring shares in Herald on the same basis, in the sense that Primeo's Herald's only assets were its investment in Bilmis.
Thank you.
Mr. Smith, again, following up on that, might it be said that in the Herald transfer, in effect, although people didn't appreciate the true position, Primeo gave assets to Herald, which were, if you like, fatally flawed by being rights in a Ponzi scheme rather than true rights to treasurers, and got back rights which were essentially equally fatally flawed in terms of being rights in a Ponzi scheme. So if one looks at this in terms of the loss suffered by Herald, it didn't really suffer any loss itself at that stage. It gave something valueless for something that it acquired, which was valueless. There may have been a separate question whether, by virtue of the nature of the account, which was then provided by Bilmis, Herald acquired, if you like, some sort of contractual right against Bilmis, such that it could sue and would get a money claim, get a claim with face value of the amount of the treasurers, which ought to have been delivered up to it. But there aren't any real treasurers there, so that's not going to be anything of real value.
Yeah.
Yes.
So sorry, just to pursue the thought through, that I just wonder whether one way of looking at this is Primeo has paid real money at an earlier stage, back in 2005 through 2007, acquired for that money assets which have effectively potentially nil value if they don't happen to try to draw on the Ponzi scheme at the right time. Do a transfer with Herald where it's like for like, so assets on both sides fatally flawed in that way. So let's call them both nil value, unless you get lucky when you try to draw. And that doesn't change, you say, the nature of the loss that actually Primeo suffered and is trying to claim in respect of in these proceedings, as I understand the way you're putting it.
Yes, I mean, if I may say so, I mean, we would exactly agree with that. I mean, that exactly reflects our analysis. And I mean, it may be that it's very important to bear in mind that Herald was only ever exclusively invested in Bilmis, because in substance, what happened is Primeo had a direct claim into Bilmis. On one view, all the Herald transfer is doing is inserting Herald as an intermediary within that, because rather than Primeo then having a direct route against Bilmis, it has an indirect route in that it has a shareholding in Herald, but Herald's only assets are its own investments in Bilmis. So on one view, all you're doing is actually just inserting Herald within the line that otherwise existed directly between Primeo and Bilmis. I mean, it is very important to have that in mind, because what one needs to be clear that by the Herald transfer, Primeo wasn't acquiring shares in some other company that had other assets. It was effectively continuing its exposure to the same Ponzi scheme as to 100%. It was just continuing that exposure indirectly rather than directly.
But I mean, yes, and it may be rather important when one's talking about whether the company suffered reasonable damage. So on this analysis, the company has a claim a contract claim against Bilmeth, but it hasn't invested any money in Bilmeth itself. It just has a contract claim, and it might be said that's rather different sort of damage from that which is talked about in the prudential case. The prudential case isn't about, do you have a claim that the company could vindicate? It seems to focus much more on, has the company suffered loss, and is that loss something that feeds through to the value of the shares by something that the company has done or has had done to it?
Yes, I mean, that's exactly right. And I mean, I think we think it's probably quite helpful just to focus on the actual movement of the cash, because if you look at the cash, then so far as the direct investments are concerned, that is cash, actual dollars that were disgorged by Primeo. Now, in relation to those same investments, the direct investments, Herald, of course, didn't disgorge any cash at all. I mean, it in effect entered into what one might describe as a paper transaction under which there was a swap of rights, but it didn't disgorge any cash. The cash was disgorged by Primeo, effectively when those monies were advanced to Bilmeth over a period of months and indeed years. I just noticed the time. I'm afraid I've omitted to stick to 11:45, but I don't know if that would be convenient to your lordships.
I wonder if it's just worth pursuing this point a little bit longer. In thinking about a potential claim by Herald, it seems to me at the moment that the best its advisors could have, or the best that the respondents could have done for Herald would have been to alert it to the fact that it had an interest in a Ponzi scheme after May 2007. And if it had been so alerted, it might have recovered more than it in fact recovered after the financial crash. But it's never going to get back what the investors had put in form of cash originally, because that money has been misappropriated.
Yes, I mean, that may well be right. We respectfully agree.
And if that's so, then it rather sounds as though it's a situation where, on any view, the loss suffered by the investors is distinct from any loss that Herald might have suffered through the fault of the respondents.
Yes.
Right. Well, shall we adjourn then, and we'll resume in about 5 minutes' time. Thank you very much.
Thank you very much, my lord.
I think we're now ready to resume. Mr. Smith.
Thank you very much, my lord. My lord, I've just been making the point that in our submission, where loss suffered in a form that is distinct and recoverable, a subsequent acquisition of shares in a company in our submission doesn't matter or change the nature of that loss.
I'm sorry, Mr. Smith. I know you've turned your volume down. I'm now having difficulty hearing you. I'm sorry.
Let me just adjust that again. Is that any better?
Yes, it is. Thank you very much.
Thank you, my lord. My lord, the other point we'd make about this is it's actually entirely unnecessary to regard the law as having that consequence. And it's unnecessary because the effect of any subsequent acquisition of shares in circumstances such as the present can be dealt with entirely adequately as part of the process of assessing damages. There's no reason why, as part of the process of assessing damages, working out the net sum which is due, one can't ascribe a value to the benefit of shares which are received. That doesn't itself present any conceptual or indeed necessarily any practical difficulty. Now, there's two further points which we'd like to make, if we may, which we suggest highlight why we're right on the timing point. The first is to consider not the facts of the present case, but the converse position. And that's to assume a situation where a shareholder had suffered loss in its capacity as shareholder by way of the diminution in value of its shares, and had a cause of action against a wrongdoer, where the company also had a cause of action against the same wrongdoer. So in other words, a situation where prudential rule would apply. But then assume that the shareholder sells his shares in the company and then issues proceedings. And we suggest that it's not right that the prudential rule wouldn't then apply simply because the claimant isn't a shareholder at the time when it actually issues the claim. In our submission, the correct analysis on that factual scenario is that when it suffered the loss, that loss was reflective in nature, it was indistinct, irrecoverable loss, and that the act of the shareholder subsequently selling his shares can't convert the nature of the loss so as then to entitle him to bring an action against the same wrongdoer. And we'll come to this again in a moment because it's relevant to a case called Nectrus, which is referred to by the parties. Another example is this. What if the company's claim becomes time barred before the shareholder's claim? One could posit a situation where there might be different limitation periods applicable to the shareholder's claim and the company's claim, perhaps because the shareholder is able to avail itself of a postponed limitation period. In our submission, it wouldn't be right that if the company's claim has become time barred because the directors have decided not to pursue it, and the shareholder then commences an action, that the prudential rule wouldn't apply. And this is in circumstances where the loss was originally suffered by the shareholder in that capacity and takes the form of a diminution in value of the shareholding. By making the investment in the company, as we explained earlier, the shareholder has effectively signed up to the bargain under which its fortunes follow those of the company. If the directors of the company decide not to pursue the claim so that it then becomes time barred, why is it that the shareholder should then be able to assert its own claim on the hypothesis that it's subject to a longer limitation period? So again, obviously not the facts of the present case, but it does in our submission tend to highlight why the correct analysis must be that the focus is on the time at which the loss is suffered and not the time at which the action is commenced. Now, that brings me to a decision in a case called Nectrus, which has been referred to in the parties' written cases. Your Lordships will find that in the electronic bundle at page 1077. Now, I should say at the outset, this is a judgment of Lord Justice Flo, sitting as a single judge of the Court of Appeal on a renewed application for permission to appeal. It's not a decision on which we rely, but it's referred to in the cases, and therefore I wanted to address it. I do point out that technically, under the applicable practice statement, which is the practice direction citation of authorities, it's not to be cited as an authority without permission. And that's because it is simply a decision of a single judge on a permission to appeal application. The exception to that is that the judgment must clearly indicate that it purports to establish a new principle or to extend the present law, but there's no statement to that effect in the present case. So I just mentioned that for completeness. So far as the facts of the case are concerned, your Lordships will see those in paragraphs 2 to 5. set out on page 1078. And essentially what happened was that a company called Nectrus provided investment advice to a company called UCP and its 100% subsidiary Candor. And that advice caused UCP to make a number of investments through Candor in certain Indian companies, which investments were then in effect lost. Now, what subsequently happened is UCP then sold its shares in Candor to an entity called Brookfield. And you can see from the final part of paragraph 3 that Brookfield paid an amount of £15.8 million. But that was to reflect the value of the investments that had otherwise been lost. Now, what then happened was that UCP claimed damages from Nectrus for the discount from the purchase price. And one of the issues that arose was whether the claim was barred by the rule in Prudential, because UCP was the shareholder in Candor, and it was Candor that had actually made the investments in the Indian SPVs and which had in essence lost those investments. So there was a reflective loss point as to whether or not that barred the claim by UCP. Now, the judge below had held that it wasn't barred, and the Court of Appeal, Lord Justice Flo, refused permission to appeal on this point. And that point is dealt with at paragraph 42 on page 1093. And it really begins at paragraph 41, where Lord Justice Flo deals with the submissions that were made in support of the renewed application for permission to appeal. And in paragraph 42, it said that the first point is that it's important to understand the nature of the claim made in the proceedings. It was in respect of a loss which UCP had suffered on its sale of its 100% shareholding in Candor. Brookfield obtained the shareholding at a discount, and it was at that time the loss crystallized. And then the submission that was made on behalf of Nectrus by Mr. Butler, Queen's Counsel, was that he sought to contend that the applicability of the rule against reflective loss should be assessed at the date the cause of action arose. In that case, the cause of action for breach of contract. And then Lord Justice Flo goes on to point out that it was actually common ground before the judge that the issue as to whether the loss is precluded by the rule against reflective losses to be assessed at the time the claim was made. And that, interestingly, was based on the Court of Appeal decision in the present case. Now, that, it might be said, isn't the solidest foundation, since that's obviously a pre-Marex decision, but also our position in the present appeal is that the decision of the Court of Appeal was wrongly decided. But nevertheless, that was the position before the judge at first instance in Nectrus. And then Lord Justice Flo goes on to say this. He says, even if that point had not been common ground, I consider that it's correct as a matter of principle that the applicability of the rule against reflective loss should be assessed when the claim is made, at a time when the loss claimed has crystallized, not at some earlier date, when although there may have been a breach of contract, the loss claimed had yet to crystallize. Now, in our submission, that is a slightly difficult passage. It's positing a choice between two alternatives for the relevant date at which you assess whether the rule applies. The first alternative Lord Justice Flo refers to is the time when the claim is made. And the second is the time when the breach of contract occurred. And that appears to reflect the way in which the argument seems to have been put by Mr. Butler for Nectrus, who was contending for the date being the date when the breach of contract occurred. You see that from paragraph 42. Now, neither of those in our submission is the correct analysis. Rather, the correct time for assessing whether the rule applies is the time when the loss was suffered. It's neither the date when the breach of contract occurred, nor is it the date when the claim was commenced. So in our submission, the choice being posited by Lord Justice Flo there is effectively the wrong choice. What he's not considering in our submission is the correct analysis, which is that you have to look at the time when the loss is suffered. So when he says, I consider it correct as a matter of principle that the applicability of the rule against reflective loss should be assessed when the claim is made, in our submission that's wrong, and he hasn't considered what we would suggest is the correct analysis, which is you look at the time when the loss is suffered. Now, he goes on in paragraph 44 to come up with well, to deal with a second point, which is simply a contention that the rule doesn't apply to claims by ex-shareholders, and this is, I think, being put as an exception or a carve-out from the rule, and it's simply being asserted that the claim doesn't apply to ex-shareholder claims. Now, this isn't a point that arises directly on the facts of the present case, clearly, since we're concerned with the converse situation. We're not concerned with a case where someone was a shareholder and then sells their shares, dealing with a case where someone wasn't a shareholder and then acquires the shares. So in that sense, it doesn't apply to the facts of our case. However, we do suggest that it may not be right in the first sentence to say that the Supreme Court in Marex were specifically considering the position in relation to a shareholder who suffers loss in that capacity who then sells its shares. If one looks at the first sentence, it seems to us that the Supreme Court in Marex don't specifically grapple with that particular situation of where someone is a shareholder who suffers a loss and then sells their shares. I mean, it appears to us that that's not a scenario that was dealt with in the judgments in Marex. And it might be possible to make the argument that once a shareholder has sold his shares, he's at that point no longer invested in the company, and his investment is no longer subject to control by the organs and constitution of the company. But in our submission, and to the extent it's relevant, we submit that isn't the correct analysis. If at the time the shareholder suffers the loss, he was a shareholder and he suffered loss in the form of diminution in value of his shares, then it's difficult to see why, as a matter of law, a subsequent sale of the shares should alter that position. And by selling the shares at his own election, the shareholder has simply crystallized a loss, which he's already suffered. And it's not unfair to the shareholder for the prudential rule to continue to apply in those circumstances. It was the shareholder's decision not to remain invested in the company, but to sell. And also his decision as to the terms on which to sell. And in that case, his decision to crystallize his loss. And if one looks at the facts of Nectrus, it was UCP's decision to structure the sale in the way in which it did. It could have mitigated against the effect of the application of the rule either by simply refusing the discount on the purchase price, or requiring Brookfield to account for the benefit of any successful claim made by Candor against Nectrus. So ultimately, so far as Nectrus is concerned, in our submission, Lord Justice Flo is wrong to say that the relevant date assessing the rule is the date when the claim is made. And also in paragraph 44, we would disagree with the proposition that there is an exception to the rule in relation to claims by ex-shareholders, although, as I say, that isn't in fact the facts of the present case. So that's Nectrus. Now, the other case I just wanted to deal with very quickly is a case called Allianz Global Investors against Barclays Bank, which is at page 1100 of the bundle. And this was a slightly different situation, because this was a circumstance where the shareholder didn't sell his shares, but rather he redeemed his shares in the company. And it may be that in relation to a redemption, the analysis is slightly different. And that's because where the redemption is at a price which takes into account the company's loss, then it may be able to say that the effect is to eliminate the company's loss and to transfer that loss to the shareholder, the redeeming shareholder, so that the shareholder is then entitled to sue without being impeded by the reflected loss rule. And I can just show you how that factual situation arose in the Allianz case and how the judge dealt with it. If you go to page 1102 of the bundle, paragraph 1, what the case concerned was damages claims against the bank, or against a number of banks, as you can see in the first page of the judgment. And the damages claims were for alleged manipulation of the foreign exchange markets. As you can see from the first and second lines of paragraph 1, the claimants were almost entirely investment funds, which is a key feature. Now, one of the arguments that was made by the defendant bank was that the relevant loss had in effect been passed on by the funds to their investors as and when those investors had redeemed their investments in the fund. And you see that argument being advanced at essentially paragraph 18 on page 1105. So what the banks were saying was that although the investment fund might have suffered loss originally by virtue of the manipulation, as and when investors in the funds redeemed, they did so at a price that was fixed by reference to the then prevailing net asset value of the fund. And the effect of that was that because the net asset value took into account the loss caused by the defendant's wrongdoing, that loss was passed on or transferred to the investors themselves, and meant that the net position was that the company didn't have any remaining claim, and that the claim had in effect been transferred to the investors. Now, the claimants sought to respond to that by saying that the shareholders couldn't have a claim because of the prudential rule, and you see that argument at paragraph 29 on page 1108. So essentially, the claimants' riposte to that argument is to say, well, that can't be right, because the investors were shareholders, and because they were shareholders, the prudential rule must apply to bar any claim by the shareholders, and that was put under the heading "the company issue," beginning at paragraph 29. Now, the court dealt with this point beginning at page 1120 of the bundle. At the very bottom of that page, there's a heading, "the company issue," which is the reflective loss point. And then the judge begins his analysis at paragraph 81. And as he says, the company issue essentially raises the question whether the rule in Prudential, as affirmed in Marex, has the result that an investor shareholder who redeems or withdraws his investment and receives a lesser sum than he would have done but for the defendant's alleged wrongdoing has no claim or cause of action against the defendants. And his argument, and the judge's conclusion on that point, is really contained at paragraphs 99 through to 101. This is page 1124. And his conclusion is that the claim of the redeeming investor is not barred by the Prudential rule. And you can see from paragraph 100 in particular that his rationale for that is that the effect of the redemption is to pass on the loss which was suffered by the company to the investor. And the reason why that happens is that when the investor redeems, he redeems at the then prevailing net asset value. The net asset value takes into account the negative effect on the company's assets caused by the wrongdoing of the bank. And therefore, the effect of the redemption at a lower price than would otherwise be achieved is to pass on that loss to the investor, or to transfer the loss to the investor. And that's his reason for then saying that the reflective loss rule doesn't bar the claim by the redeeming shareholder. Now, in our submission, that analysis may well be correct, but the reason why it's correct is tied to the facts of that case, and it's simply because the feature of a redemption by an investor at the prevailing net asset value will be to transfer the loss from the company to the investor. So to the extent Sir Nigel Tier was right in that case to look at the effect of the subsequent redemption, it's because the particular effect of a redemption at net asset value can be said to transfer or pass on the company's loss to the investor. And that's because what the company has done through the redemption is extinguish its own liability to the investor in respect of the redemption price for a reduced amount, which takes into account the loss which the company has itself suffered through the reduction in value of its assets. And the company can't then claim that loss from the wrongdoer, but there's no reason why the shareholder can't. So in our submission, that decision on the facts of the case might be said to be correct, but it's a decision that turns on the particular features of a redemption, and in particular a redemption which is made at the prevailing net asset value. So, Lord Sales.
Yes, what happens in that situation where the company hasn't given up its cause of action, it's just that it suffered a loss and it has a cause of action in place of what were real assets. It plans to continue to pursue that cause of action, but the net asset value when it's struck at any particular point of time has to give a discounted value reflecting that you haven't won your case yet, you just have a cause of action. So I'm just struggling a little bit, because there the company will be still pursuing its underlying cause of action, and as I understand it, you're saying but still the shareholder can pursue their cause of action as well.
Yes, I mean, I think the judge's analysis in that case would be to say that where there is a redemption of a particular portion of the shares in the company at the prevailing net asset value, then the loss, which is attributable to the amount by which that net asset value is less than it otherwise would have been if there hadn't been any wrongdoing, is in effect passed on or transferred between the company and the shareholder. It's loss that's transferred or passed on, to use his language, from the company to the shareholder. Now, I mean, just to be clear, so far as this case is concerned, it's not a case I positively rely on. But what I would say about it is simply that, to the extent it is an example of where the court has looked at steps which have taken place post suffering of the loss, and has concluded that the shareholder's claim isn't necessarily barred by the prudential rule, that's because of the particular features of that case, and in particular the consequences of a redemption at the net asset value.
All right, thank you.
So it's not a case I positively rely on, but I just make that point because it is an example of a case where the court has looked at events post the suffering of the loss and concluded the claim isn't barred. But as I say, it's for those very specific reasons. And I mean, one can argue whether the reasoning is right or wrong, but on any view, it turns on the redemption at the net asset value. So that, I think, sort of brings me to the end of the timing point, and ultimately our submission, which I think fundamentally goes back to the analysis of the Supreme Court in Marex, is the correct analysis. Is that you need to focus on the question of loss. You need to look at the capacity in which it was suffered and the form it takes, and ask oneself, well, is that loss distinct or indistinct? Is it recoverable or irrecoverable? And in our submission, that isn't what the Court of Appeal did in the present case. So, my Lord, I think that brings me to the next topic in my submissions, which concerns the requirement for the company and the shareholder to have a claim against the same wrongdoer. That is an essential precondition to the application of the rule, as stated by the Supreme Court in Marex. And in our submission, it reflects the fact that the origins of the prudential rule ultimately lie in the rule in Foss and Harbottle itself, and that's concerned with ensuring that the company's cause of action against a particular wrongdoer can only be prosecuted by the company itself. If the shareholder's cause of action is against someone different, then it's not interfering with the company's cause of action, and it's not engaging in the sort of mischief which the rule in Foss and Harbottle was designed to prevent. Now, this then gives rise to some questions which arise on the facts of the present case, and the first and foremost point concerns the position of the first respondent. Now, the first respondent, Bank of Bermuda Cayman Limited, was the former administrator to Primeo. And as I explained, Primeo's breach of duty claims include claims against the first respondent in its capacity as former administrator. However, the first respondent was not the administrator or custodian of either Herald or Alpha. It's common ground that neither Herald nor Alpha have or had any contractual relationship with the first respondent, and it's in the statement of facts, read statement of facts, paragraphs 20, 21 and 24. Likewise, it's common ground that neither Herald nor Alpha have asserted any claims against the first respondent. Now, in those circumstances, our short point is that the prudential rule cannot, on any view, operate to exclude Primeo's claims against the first respondent. And that's simply for the reason that neither Herald nor Alpha have a claim against the first respondent. So we're not in a situation, so far as those claims are concerned, of the relevant company, in this case Herald or Alpha, having a claim against the same wrongdoer. Now, the Court of Appeal dealt with this point in paragraph 424 of their judgment, which is at page 328 of the electronic bundle. If I can just show you that. And it's in particular subparagraph B in paragraph 424 on page 328. Now, what they relied on for the purposes of their conclusion was that there were delegation agreements in place. And in particular, there was a delegation agreement for Primeo, whereby the first respondent delegated performance of its functions as administrator to the second respondent. And we have copies in the bundle. I don't think the detail matters too much, but just so you can see the format, we go very quickly to page 431. You see delegation agreement, and this is the delegation agreement between the first respondent and the second respondent. And if you go to page 433, clause 2, it's very straightforward, but essentially what the first respondent is doing is appointing the second respondent to carry out its functions and duties. But you will also note from both page 431 and 432 that Primeo isn't a party to this. It's essentially an internal document between the two Bank of Bermuda's entities. And similarly, there was a delegation agreement for Herald, whereby a different Bank of Bermuda entity delegated to the second respondent the performance of its functions as administrator to Herald, and you have a copy of that at page 483. Sorry, this is for Alpha. There's a similar agreement as well for Herald, essentially in the same form. So if we go back to the Court of Appeals analysis on page 328 and page 424, what the way they approached it was to say, well, the effect of the delegation agreements means that the substance of the duties was carried out by the same person, in other words, the second respondent. And that they also relied on the fact that they said the second respondent would be liable to the relevant Bank of Bermuda entity, which was the actual administrator, for any negligent performance of the delegated duties. So there's essentially 2 points which they make. They say, as a matter of substance, it was the second respondent who was actually doing the work under the delegation agreements, but also if the second respondent acted negligently, then the first respondent and the other Bank of Bermuda entity would have a claim against the second respondent. And in effect, what they're saying is that the position of the actual administrators can be ignored, and that Primeo and Herald can each be treated as having a claim directly against the second respondent. Now, in our submission, that, with respect to the Court of Appeal, misconceived. Firstly, we submit that there isn't any legal basis for simply ignoring separate corporate personality in this way. I mean, in effect, the approach is simply to ignore the position of the entity which is the actual administrator, and we respectfully suggest there isn't a legal basis for ignoring the separate corporate existence in that way. But secondly, and perhaps more substantively, in order to determine whether the prudential rule applies, the focus is on the entity against whom the company and the shareholder have their respective claims. And that's because mischief against which the rule protects only arises where the shareholder is suing the same person as the company and thereby interfering wrongfully with the company's claim against that person. What it's concerned with is a situation where the company has a claim against a specific person and the shareholder interferes with that claim by essentially bringing a same claim against the same person. Now, the fact that the person against whom the shareholder has a claim, who we might describe as person A, may in turn have a claim against the same person as the company's claim lies, is not something that is the responsibility or fault of the shareholder, or we would suggest a sufficient reason to bar the shareholder's claim at all. So far as the shareholder's concerned, it may simply know nothing about what the arrangements are beyond the person against whom it is asserting a claim. And if a shareholder has a claim against person A and the company has a claim against person B, there's no reason why, in our submission, the fact that person A may in turn have a claim against person B means that the shareholder's claim ought to be barred. I mean, what the shareholder is doing is not itself interfering with the company's claim. And in our submission, that doesn't engage the mischief of the Foss-and-Harbottle rule or the prudential rule. And thirdly, the Court of Appeal's approach has the benefit of conferring a wholly unjustified windfall on the first respondent and its creditors and shareholders, because the net result of this is that the first respondent ends up in a position where the claim by Primeo against it is barred, supposedly because of the prudential rule, but at the same time it's not subject to any claim by Herald or Alpha. So how is it, one asks, that it could possibly be right where the first respondent ends up getting off entirely scot-free, particularly in circumstances where the Court of Appeal has held that the claim as to duty, breach, limitation, and indeed gross negligence has been established? I mean, how can it be right that the first respondent ends up in a situation where it has no claim at all against it? It is essentially in a position where it doesn't have to face liability to anyone. And in our submission, that must be wrong. There's absolutely no warrant at all for the first respondent being left in that position. And we submit that shows that the Court of Appeal's analysis must be faulty. And then the final and fourth point we would make in relation to this is that there is no evidence, or was no evidence, that the first respondent would in fact have a valid claim against the second respondent. The Court of Appeal's analysis relied on the terms of the exoneration clause in the delegation agreement, which left open the possibility of the first respondent bringing a claim against the second respondent. But of course, whether the first respondent would in fact have a claim would depend on the evidence. And for example, had the first respondent waived its claim, had it acquiesced in any breaches, was it now stopped from making a claim? The respondents didn't put forward any evidence at all on those points. There was no evidence, for example, from any director of the first respondent indicating that it believed it had a claim or that it would look to bring a claim. And evidentially, in our submission, there simply wasn't any basis on which it could be concluded that the first respondent did have a claim against the second respondent. And related to that, we would make the point that it might be said with perhaps some force that the Court of Appeal's analysis on this point is somewhat detached from reality, because of course what we're concerned with here are all companies which are all entities within the HSBC group of companies, and one assumes that in reality they're probably not going to spend time suing each other. It would seem a wholly artificial exercise for them to do so. The delegation agreement is clearly an internal document that was put in place essentially for internal purposes. Primeo wasn't a party to it, as I say, and the idea that the claim against the first respondent of Primeo ought to be barred because of the first respondent's potential for a claim against the second respondent, in our submission, is artificial.
It rather looks as though the idea in 424 rather looks like an idea that we criticize in Marex, namely that if you have two persons, each with a claim against a third party, and one of those persons is an insolvent company, then its claim is to be given priority.
Yes.
It's just nonsense. It seemed to be a confusion about the pari passu rule. So here, Primeo and Herald would both, well, they're saying that Herald has a claim against R2 and Primeo has what in substance would amount to a claim against R2. And since Herald is insolvent, the consequence would be, if Primeo's claim was accepted, the extraction of value at the expense of Herald's other shareholders and creditors.
Yes. Yes, I mean, if I may say so, I think that must be right. I think it's a sort of unspoken premise underlying that part of the analysis that they assume that Herald's claim ought to have priority.
Yeah. The same idea was developed by the Court of Appeal, English Court of Appeal in Marex, and I hope we exploded it in our judgments.
I think your lordships did. So we do respectfully submit that this part of the this part of the Court of Appeal's analysis on any view doesn't stand up to scrutiny. And there's a similar point in relation to the argument that Primeo's claims against the respondents are reflective of Alpha's claims. Now Alpha, as we explained earlier, is less significant in the overall picture because the amount of Primeo's shareholding in Alpha is much smaller than that which it held in Herald. But there is a similar point in relation to the attempt to rely on claims against Alpha as a basis for applying the reflective loss principle. And that's because Alpha had no contractual relationship with either the first respondent or the second respondent. And the reasoning of the Court of Appeal was essentially based on the same pass-through analysis, which we've already seen. And we'll just give you the references quickly. It's, first of all, paragraph 359 at page 306. And as you can see from 359, the custodian for Alpha was a different entity, Bank of Bermuda Limited. And then there was, again, a delegation agreement under a sub-custodian agreement to the second respondent. So again, it's the similar sort of structure. And then at paragraph 425, they deal with the administrator, and there was some lack of clarity on the evidence as to who the administrator actually was, surprisingly. But then it was the same point that the second respondent was again the delegate of the administrator. And again, as you can see from the final part of 425, the analysis is based on the idea that the administrator would have its own claim against the second respondent. And then when you get to 440, which is page 334, it's towards the end of that long paragraph, the anti-penultimate sentence. They effectively conclude that the terms of Alpha's administration agreement with Bermudan administrator and the delegation, exoneration, indemnity provisions in it, to which we refer 359. Now that's an incorrect reference. I think it probably must be 425. Mean that the agreement is substantially the same as Primeo's administration agreement with R1. So essentially the analysis of the Court of Appeal is the same, that although the administrator and custodian weren't either R1 or R2, it said that because everything was in effect subcontracted to R2, that is sufficient, because the entity which was the administrator or custodian would have its own claim against R2, and therefore Primeo would be indirectly interfering with Alpha's claim against that entity. But we submit, again, that's wrong for all the reasons we've been through, which apply equally to this scenario. It ignores the separate corporate personality. It ignores that the focus must be on the persons against whom the shareholder and the company have their own claims, and not on the persons against whom claims may in turn lie. And it confers an unjustified windfall on the respondents, because they're able to rely on Alpha's claims to block Primeo's claims in circumstances where they have no contractual relationship with Alpha themselves. So that's a further topic which, in our submission, is a discrete and freestanding reason why the Court of Appeal's analysis on those points is wrong. My next topic is the question of the merits test. I'm just looking at the time. It might be worth me just making a start on that, or thank you. The merits test concerns the question of what threshold test should be applied to the strength of the company's claims against the wrongdoer before the rule in Prudential is applied to bar the shareholder's own claim. The courts below considered that it is sufficient that the company's claim against the wrongdoer is realistic. And that was the Court of Appeal judgment at paragraph 438. And that formulation was picked up from a formulation which had been used by a judge at first instance in an English case called Perry against Day, which in fact your lordships overruled in Marex, although your lordships weren't engaging with this point specifically. In our submission, that test of a realistic claim is wrong, and the relevant test should be that the company's claim is likely to succeed, applying the usual balance of probabilities test. Now, this issue has not been clearly dealt with in the existing authorities prior to the present case. There's as I say, the statement of His Honour Judge Rich in Perry and Day. There was also a statement to the contrary effect of Mr. Justice Rymer, as he then was in an earlier decision in Perry and Day, who came to a different conclusion as to the test to be applied. But there hasn't, I think, been a case which has analysed the test and the rationale for it. In our submission, that may not be entirely surprising, and that's because in most cases where the prudential rule potentially applies, the claims of the company and the shareholder against the wrongdoer will arise out of the same facts and be governed by the same system of law. So in most cases, it will be relatively easy to conclude that if the shareholder has a good claim against the wrongdoer, then the company will have a good claim. And indeed, in most situations where the prudential rule potentially applies, it may be relatively easy to conclude that the company's claim is, relatively speaking, likely to have better merits than that of the shareholder. And the reason I say that is that when one thinks of the type of situations where the rule in prudential has been engaged in the past, they perhaps fall into two categories. The first is where a wrongdoer has caused some harm to the company, and the shareholder is seeking to bring a claim in reliance on some economic tort theory. And that would be the situation, obviously, in prudential itself. It was also, in effect, the situation in Marex. The other type of claim is what one might call a parallel duty of care type scenario, where, again, the wrongdoer has caused loss to the company, and the shareholder is alleging that a parallel duty of care was owed by the wrongdoer to the shareholder himself, and that's the Johnson and Gore Wood or Perry and Day type of scenario. It was also the position, I think, in the Bearings case. So one has those two sorts of situations, but in those situations, it might be said that it's the company which is ordinarily most proximate to the wrongdoer, and that the shareholder who is seeking to rely either on an economic tort theory or a parallel duty of care of some kind, who is seeking to bring his own claim. And in those sorts of scenarios, I would suggest it's going to be relatively easy probably to conclude that if the shareholder has a good claim, then the company has at least a good claim and is probably likely to have a better claim. And to that extent, it may be said that it's a premise underlying the prudential rule that, relatively speaking, the company's claim against the wrongdoer is of better or at least equivalent merit to the shareholder's claim. I mean, certainly that was the position in prudential itself, where the shareholder's conspiracy claim was on any view a more difficult claim than the company's claim. Now, the problem arises in the present case because, unusually, that sort of fact pattern doesn't arise, and there is no basis for proceeding on the assumption that the company's claim against the wrongdoer is of better or at least equivalent merit to the shareholder's claim. And the reason why that issue arises in this case is that Primeo's claims against the respondents are governed by Cayman law, which is the law applicable to the administration agreement and the custodian agreement, and subject to the jurisdiction of the Cayman courts. And as your lordship know, Cayman law is for all intents and purposes the same as English law for these purposes. However, in contrast to that, the claims of Herald against the second respondent are governed by Luxembourg law, which is the law applicable to the Herald administration and custodian agreements, and they're subject to the jurisdiction of the Luxembourg courts. So one's in a situation, perhaps unusually, where, because of the different applicable laws and jurisdictions, it's entirely possible for Primeo to have a very good claim against the respondents, but for Herald to only have a bad claim against the second respondent. And the question is, well, how is that particular conundrum to be approached? Now, my lord, just looking at the time, that might be a convenient moment. I've effectively introduced this topic, but I'm going to develop it.
Well, when we resume, it might be helpful for us if you could tell us which proceedings brought by Herald and Alpha are still pending, because we've been told, I think, about 3 sets of proceedings brought by Herald and 2 brought by Alpha. And also, if you could tell us why we shouldn't simply say claim by why do we have to form a view about the prospect of success in Luxembourg proceedings governed by Luxembourg law rather than simply wait and see?
Well,
But we can,
the short answer to that is that the Herald claim was commenced in 2009 and it's still going, with no end in sight. But I'll deal with that. Thank you, my lord. After we come back.
very well. We'll adjourn now and resume at 2 o'clock.
You heard.